Welcome to City Education, your home for education in all forms, shapes, and sizes. Today's journey takes us into one of the most powerful and most transformative provisions in our country, the Bill of Rights, Section 9, the right to equality. We'll explore how courts have developed tests to determine when the law is fair, when it is discriminatory, and when it's constitutionally justified. From the Prinsloo v. Vendor Linde rationality test to the Heerden test for affirmative action. We'll break it all down step by step, using real constitutional court cases and expert commentary from Currie and Waal to bring the principle to life. So, whether you're a law student, a legal professional, or just a curious mind, stick around. Before we dive into it, remember to like, share, and subscribe. Now, before we can understand legal tests, we need to know the constitutional foundation they are built on. Section 9 of the Constitution, our Equality Clause, is more than just a promise of fairness. It is a roadmap for achieving a just and inclusive society. Section 9, Section 1 guarantees that everyone is equal before the law and entitled to equal protection and benefit of the law. This is where the principle of formal equality lives, treating people in the same position in the same way. Section 9, Subsection 2 moves beyond formal equality into the realm of substantive equality. It says that the state may take legislative or other measures to protect or advance people disadvantaged by unfair discrimination. This is where affirmative action measures come in, and where the Heerden test applies. Section 9, Subsection 3 prohibits unfair discrimination by the state on specific listed grounds like race, gender, age, disability, and more. Section 9, Subsection 4 extends this prohibition to private individuals and organizations, requiring national legislation to prevent and prohibit such discrimination. Section 9, Subsection 5 creates a presumption. It outlines that if discrimination is on one of the listed grounds, it is presumed to be unfair unless proven otherwise. Together, these subsections address two big questions. Firstly, when does treating people differently amount to unfair discrimination? Secondly, when can the state legitimately take positive steps to level the playing field? The answers to those questions come from two key constitutional court decisions, Prinsloo v. Vendor Linde and Minister of Finance v. Van Heerden. Each developed its own test for interpreting Section 9. Our first stop is in the Princeton case, a 1997 decision that laid the groundwork for dealing with mere differentiation under Section 9, Subsection 1. The facts were unusual. Landowners in certain fire control areas were treated differently from those outside these areas. The question was, could the law make this distinction and still be constitutional? The Constitutional Court, led by Justice Ackerman, developed what we call today the Prinsloo rationality test. It is a three-step process. Step 1. You have to ask yourself, is there differentiation? Does the law or conduct treat people of groups differently? This can be based on any characteristic, geography, occupation, status, or otherwise.
Step 2.
Is there a legitimate government purpose? In other words, is there differentiation aimed at achieving a lawful or reasonable objective? The purpose must be constitutionally permissible, not arbitrary, biased, or capricious. Step 3. Is there a rational connection between the differentiation and the purpose? Meaning, is there a link between the means and the ends? This is not about fairness or reasonableness, only about whether the connection is rational. Now, if the answer is yes to all three, the differentiation passes the rationality test and thus does not violate Section 9, Subsection 1. The principal test reminds us that not all differentiation is unconstitutional. Sometimes it is simply part of how the law functions, for as long as it is rational. While the Prinsloo deals with ordinary differentiation, Minister of Finance v. Van Heerden addresses a different question. When is it constitutionally permissible to treat people differently in order to redress past advantages?
The case concerned
changes to the parliamentary pension scheme, which gave certain benefits to black MPs who had served in parliament during apartheid, but not to their white counterparts. Justice Muskoneke, in writing for the majority, recognized that equality is not just about treating everyone the same. it is also about actively undoing the structural disadvantages created by our history. The court set out a three-part test to determine if a measure falls within the protection of Section 9, subsection 2. Step 1. Target group. Here we ask, does the measure target persons or categories of persons who have been disadvantaged by unfair discrimination? Step 2. Advancement purpose. Here we ask, is the measure designed to protect or advance such persons or category of persons? Here, a naked preference is prohibited. There must be a genuine remedial or protective purpose. Step 3. Promotion of equality. Does the measure promote the achievement of equality? This involves a balancing exercise. The measure must contribute to substantive equality, even if it comes at the cost of those who were previously advantaged. If a measure meets all these three requirements, it is not considered unfair discrimination under the Constitution. As Justice Montenegro put it in paragraph 44, it must be accepted that the achievement of this goal may often come at the price of groups who were previously advantaged. This test is now central to elevating affirmative action measures, from employment equity to transformative policies in various sectors. Now that we've seen both tests in action, how do we know which one to apply? The key lies in the purpose of the differentiation. If the measure is not designed as an affirmative action measure under Section 9, subsection 2, but still treats people differently, the Prinsloo rationality test applies. Here, the focus is on whether there is a legitimate purpose and a rational connection between the differentiation and the purpose. On the other hand, if the measure is an affirmative action policy aimed at addressing a historical disadvantage, the von Heerden three-step test applies. In this case, the focus shifts from mere rationality to whether the measure genuinely advances substantive equality for disadvantaged groups. Think about it this way. Prinsloo asks, is this differentiation rational? Van then asks, does this measure truly advance equality for the disadvantaged? It is important to note that even if a measure passes Prinsloo's rationality test, it might still be challenged under Section 9, subsection 3 through 25. That is if it results in unfair discrimination on prohibited grounds. These two tests form the backbone of South Africa's equality jurisprudence. The Prinsloo and van Heerden test didn't stay confined to their original cases. They've shaped how our courts approach equality disputes ever since. Now here's a list of a few cases that applied these principles. Number 1 is the South African Police Service versus Solidarity Obo Barnard case. Number 2, Bay versus Magistrate Haile Shah. Number 3, Minister of Constitutional Development versus SARIPA. Number 4, Sarrahwitz versus Maurice. These cases show that equality analysis is context-specific. Sometimes the courts applaud measures as advancing equality. Other times, they strike them down for being irrational, overboard, or not genuinely remedial. Now, legal tests do not exist in vacuum. Scholars help us understand their strengths, limits, and practical application. Currie and Waal, in the Bill of Rights Handbook, provide valuable insight into both Prinsloo and van Heerden. On the Prinsloo rationality test, they note that Section 9, subsection 1 is aimed at preventing arbitrary state action. The rationality standard is deliberately low. A measure will survive if there is a plausible link between the differentiation and the legitimate purpose. This ensures that the courts do not second-guess every policy choice, but it also means irrational laws are struck down quickly. On the van Heerden test, Currie and Waal emphasize that Section 9, subsection 2 marks a shift from formal equality to substantive equality. They accept that achieving equality may require differential treatment and even temporary limitation of benefits for previously advantaged groups. They also warn that the van Heerden test must be applied with key. Measures must be genuinely linked to advancing those disadvantaged by unfair discrimination. Policies that are inflexible, overbroad, or untethered to actual advantage risk failing the third requirement, promoting the achievement of equality. Finally, Currie and Waal remind us that both tests interact with the unfair discrimination inquiry under Section 9.3 through 2.5. Passing irrationality or affirmative action test doesn't automatically shield a measure from being struck down if it still results in unfair discrimination or prohibited grounds. In short, their analysis shows that equality in our Constitution is dynamic. It demands both principled reasoning from the courts and careful design from policymakers. Now, Section 9 of our Constitution is a powerful safeguard. It protects against both unfair discrimination and irrational differentiation, while also empowering the state to take positive steps towards real equality. From Prinsloo versus van der Linde, we learn the 3 steps rationality test for ordinary differentiation under Section 9, subsection 1. From Minister of Finance Vices van Heerden, we explore the 3-step test for affirmative action under Section 9, subsection 2. It is important to note that equality is not a static goal. It is an ongoing process that requires vigilance, fairness, and a willingness to correct historical wrongs. The Constitution gives us the tools. It is up to all of us to make them work. If you find this video valuable, like, share, and subscribe to City Education, your home for knowledge in all forms, shapes, and sizes. Remember, the law belongs to everyone, and understanding it is the first step to using it.